Have you ever maybe searched your own name online
Yeah.
and found some old information you'd rather keep private?
Yeah, something that's just not relevant anymore, maybe even a bit awkward.
Exactly. Well, what if you could actually ask for that stuff to be removed from search results?
That's the core idea we're exploring today.
Welcome to the deep dive. Today, we're really getting into a landmark legal case that honestly dramatically reshaped our digital rights. It's the Google Spain ruling by the European Court of Justice.
And this judgment, it introduced this really powerful concept, often called the right to be forgotten.
Yeah, it's fascinating.
So for this deep dive, we're looking closely at a legal analysis from the European Data Protection Law Review. It's an article by Herk Kranenborg,
Right.
and it meticulously breaks down that 2014 judgment. The case C13121, Google Spain and Google Inc. versus the Spanish Data Protection Agency, APD, and Mario Costesa Gonzalez.
Okay. So our mission today is basically to unpack this really complex legal decision. We'll look at the backstory, the facts, the critical questions the court had to answer about who's actually responsible for data online.
And how it tried to strike a new balance, really, between your individual privacy and, well, the public's access to information.
Get ready for some maybe some aha moments about your own digital footprint. It definitely made me think.
Me too.
So let's start at the beginning. Who is the person at the center of all this?
Right. The protagonist, if you will, was Mario Costejo Gonzalez. He's a Spanish national. And back in 2010, he lodged a complaint with the Spanish Data Protection Authority, the AEPD.
Okay, and who is he complaining about?
Well, two different entities. First, the newspaper La Vanguardia, and second, significantly, Google Spain and Google Inc.
Got it. So what was the actual problem? What was he seeing online?
Well, the heart of his issue was pretty straightforward, but it posed this huge legal challenge. When someone searched his name on Google,
Right.
the results showed links to two old pages from La Vanguardia, pages originally published way back in 1998.
1998. Wow. Okay. What was on them?
They contained an official notice about a real estate auction, and it was related to Social Security debts he'd incurred at the time.
Ah, okay. So debts from over a decade earlier were still popping up in search results.
Exactly. And his argument was clear. Look, these attachment proceedings, they were resolved years ago. This reference is now, quote, entirely irrelevant.
Makes sense. So what did he ask for?
He asked La Vanguardia to either remove or alter those old pages. But, maybe more critically for this case, he asked Google Spain and Google Inc. to remove or, conceal that personal data from their search results. Stop linking to it under his name.
Okay, so how did the Spanish authority, the AEPD, react initially?
Well, it was a split decision. They actually rejected the complaint against the newspaper La Vanguardia.
Oh, why?
They said the original publication was legally justified. It was actually ordered by the Ministry of Labor and Social Affairs back then to ensure maximum publicity for the auction. Standard procedure.
Okay, so the newspaper was off the hook. What about Google?
That's where it got interesting. The AEPD upheld the complaint against Google Spain and Google Inc. They ordered Google to withdraw the data, basically, to remove those links from searches for his name.
Wow. So the authority agreed with him regarding Google, but not the original publisher.
Precisely. And that's really when this case took the leap to the European level.
Right, because Google presumably appealed this.
Well, the case went to the Spanish National High Court, and they were facing this genuinely new question, right? What are the obligations of search engines regarding personal data? It wasn't clear under existing law.
So they needed guidance from higher up.
Exactly. They decided to request what's called a preliminary ruling from the Court of Justice of the European Union, the CJEU.
That's like the Spanish court saying, okay, EU top court, we've got a tough one here. How does EU law apply in the situation?
That's a good way to put it. They needed clarification on interpreting the EU's own data protection rules.
And, thinking about it, you've probably felt that little pang of concern, haven't you? Seeing old stuff about yourself online that you wish wasn't there.
Absolutely. This case is such a perfect example of why this matters so deeply for your digital identity.
Yeah.
And how the law is often playing catch up with technology.
That's a really powerful point, and it perfectly sets the stage for how the EU court started to tackle these huge questions. So let's unpack that first major legal hurdle they had to jump over.
Okay, the very first, and maybe the most fundamental hurdle, was figuring out if Google, just as a search engine, could even be considered a data processor.
Someone who just handles information.
Right. And even more critically, could it be a controller, the one who actually decides what happens to that data and why?
Okay, those sound like technical terms, but they're obviously crucial in privacy law.
Absolutely fundamental.
Yeah,
And remember, the legal framework they were using was Directive 9546EC, enacted in 1995.
1995.
Yeah. I mean, try regulating the modern internet with laws from a time when the web was, barely a whisper and mobile phones were, well, bricks.
Puts it into perspective, doesn't it? So the core questions from the Spanish court were just foundational. Like, how did they even start to figure out if a search engine, something we just use every day, is processing personal data, legally speaking?
And was Google itself the controller responsible for all that? Well,
Yeah.
the court's answer was pretty clear, yes, on both counts.
Really?
Both, yes. It found that search engine activities, finding, indexing, storing, making information available, do constitute processing, even if the data is already public somewhere else and Google hasn't altered it.
Okay, that's big. And the controller part?
Crucially, yes, the court ruled the search engine operator is the controller. Why? Because it determines the purposes and means of that processing. Google decides how to index, what to show, how to rank it.
So the court emphasized Google's, decisive role in spreading the data.
Exactly. They highlighted how search engines enable users to establish a more or less detailed profile of the data subject. This significantly and additionally affects privacy rights compared to just the original website publisher.
That's a huge shift in thinking, isn't it? Before this, weren't search engines often seen as, I don't know, neutral platforms? Like
Yeah.
librarians just pointing you to the books?
That was definitely a common view, and closer to the view the Advocate General took.
Ah, the Advocate General, the legal advisor to the court.
Yes. The AG had a much more, let's say, reserved view. Suggested Google was mostly a passive intermediary, not a controller, maybe except for very specific things like the snippet shown in results.
But the court disagreed.
Explicitly rejected that more limited interpretation. They saw Google's role as much more active and impactful on privacy.
Okay, so hurdle one cleared. Google is processing data, and it is the controller. But then there's the sheer global nature of Google itself. How did the court deal with the question of jurisdiction? Did EU law even apply to a company mostly based in the US?
Another massive question. Google's argument essentially was, hey, the actual number crunching, the data processing, that happens via Google Inc. in the US, Google Spain here in the EU. That's just for selling ads.
So trying to separate the technical side from the business side within the EU?
Exactly. But the court didn't accept that separation. Again, the answer was yes, EU law does apply.
How did they justify that?
They concluded that Google Spain was an establishment in the EU, and crucially, the activities of Google Spain, selling ads, and Google Inc., running the search engine, were inextricably linked.
Ah, the link.
Yeah, the advertising made the search engine profitable, and the search engine provided the platform for the ads. You couldn't really separate them cleanly for legal purposes.
That makes sense. It's a pragmatic approach,
It
really.
was crucial. Otherwise, individuals in the EU could potentially be left without protection just because the main servers or the parent company were elsewhere. It closed a big potential loophole.
It's like saying you can't run a restaurant chain here and claim the head chef back home is the only one responsible if the food makes people sick.
A good analogy. And this source, the Kranenberg article, raises a fascinating historical side point. The old 95 directive also had this criterion about applying the rules based on the use of equipment in an EU country.
Use of equipment, like servers.
Yeah, but that's become largely outdated now, right? With cloud computing, data centers can be anywhere, often kept secret. It's not a reliable hook anymore.
True, everything is distributed now. And I remember this ruling caused quite a stir, didn't it? Weren't there criticisms?
Oh, definitely. Some critics, like the legal scholar Christopher Kuhner, raised concerns. He worried this could effectively create a sort of EU internet, separate from the global web.
Oh, so.
Well, if search results were removed only for searches done from the EU, you could end up with these parallel digital realities, as he put it, different information depending on where you search from.
That's a complex issue. Did the EU address that later?
Well, it's clear they were already thinking along these lines, even before this judgment. The new data protection rules being drafted at the time, which eventually became the GDPR,
The GDPR, right.
they directly tackled this. They basically got rid of that old equipment rule and explicitly said the rules apply if you're offering goods or services to people in the EU or if you're monitoring their behavior within the EU, regardless of where your company or servers are based.
So, future-proofing the law against these jurisdictional challenges.
Pretty much, making it much more robust for the globalized internet.
Okay, so we've established Google is a controller and EU law applies. Foundational questions answered. Now let's get to the heart of it. What did the court actually say about this specific right to be forgotten that Mr. Cosecha Gonzalez was asking for?
Right, so how did they derive this right? The court essentially found it embedded within the existing 1995 directive. They didn't invent it out of thin air.
Where did they find it?
They looked at specific articles. Article 12b, about your right to get data rectified, erased, or blocked if it doesn't comply with the rules. And Article 14.1, your right to object to processing in certain situations.
Okay.
And crucially, they interpreted Article 6, which talks about data quality. They reasoned that data processing that was initially lawful and fine. Well, it could become incompatible with the directive over time.
How?
If the data is, quote, inadequate, irrelevant, or no longer relevant, or excessive in relation to the original purpose, and considering the time that has elapsed. Basically, if it's old and unnecessary.
So context and time really matter.
Absolutely.
Oh.
And central to applying this was a crucial balancing test.
The balancing act. Privacy versus what?
Exactly. The court focused on Article 7 of the directive. This allows data processing if it's necessary for the legitimate interests pursued by the controller, like Google's economic interest,
Yeah.
or third parties, like the public wanting information.
Yeah.
Unless those interests are overridden by the fundamental rights and freedoms of the data subject, particularly their right to privacy and data protection, which come from Articles 7 and 8 of the EU Charter of Fundamental Rights.
Okay, so it's weighing Google's interests and the public's interest against the individual's privacy rights. How did that balance usually tip, according to the court?
This is where the ruling gets really significant. The court stated that, as a general rule, the data subject's rights, their privacy rights, override not only the economic interest of the search engine, but also the general public's interest in finding that information when searching for the person's name.
Wow, that's a strong statement. It really tilts towards the individual.
It does. It's a very significant tilt towards individual control over personal information found via name searches.
But.
There's always a but.
Right, it wasn't absolute. The court added nuance. This balance can shift in specific cases.
When would it shift? It depends on factors like the nature of the information. How sensitive is it for the person's private life? And also the interest of the public in having that information. Particularly, they mentioned, if the person plays a role in public life.
So if you're a public figure, the public's right to know might weigh more heavily.
Potentially, yes. The balance might tip differently.
Now, you mentioned earlier the court treated Google differently from the original publisher, La Vanguardia. Why was that distinction so important here?
It was absolutely critical to the whole ruling. The court strongly emphasized that what a search engine does is separate from and comes in addition to what the original website publisher does.
Separate and additional. How?
Well, think about it. A search engine makes finding information appreciably easier. It gathers info from all over the web and presents it linked to your name. This, the court said, plays a decisive role in the dissemination of that data.
Okay, it amplifies it, makes it easier to construct a profile.
Exactly.
Yeah.
And therefore, it constitutes a more significant interference with a person's privacy than just the original publication sitting on some isolated web page somewhere.
Right. And that distinction allowed the court to say.
It allowed them to rule that search engines could be ordered to remove links, even if the original web page itself remained lawful and unaltered, like the La Vanguardia article.
That's the key part. Why? Why allow that discrepancy?
Because, the court argued, effective data protection wouldn't be achieved if individuals always had to go after the original publishers first. Think how easily content gets copied online.
True, it's whack-a-mole.
And publishers aren't always based in the EU or even identifiable. So targeting the search engine, the main gateway to that information for most people, was seen as a necessary and proportionate measure for protecting privacy rights effectively.
Okay, that logic makes sense from a practical data protection standpoint. So
Right.
Applying all this, what was the final outcome for Mr. Costefa Gonzalez himself?
The court looked at the facts. The information was about debts, which is sensitive. And it was 16 years old by the time the complaint reached the EU court.
Right.
So, given that sensitivity and age, the court ruled that Mr. Costeja Gonzalez did have a right for that information to no longer be linked to his name in search results. They found there was no preponderant interest of the public in accessing that specific old debt information via a search for his name that would justify overriding his privacy rights.
So he won, essentially. Google had to remove the links.
Yes, the Spanish court was basically told that ordering Google to remove the links was compatible with EU law in this specific case.
Okay, so what did this all mean for the wider world? I mean, this ruling made headlines globally, didn't it? It sparked a lot of debate right away.
It absolutely did. It was huge. It was widely reported, as we said, as acknowledging this right to be forgotten, specifically against search engine operators.
Letting people kind of polish their online image, that ego surfing idea.
Sort of, yeah. It definitely reinforced the idea of individual control over your data in a way that hadn't really been established before against such powerful intermediaries.
But it wasn't universally popular, right? There was pushback.
Oh, definitely. Criticism came quickly. Digital rights groups like European Digital Rights, EDR, they voiced concerns. They felt the ruling didn't give enough weight to freedom of expression and the public's right to access information.
Okay, the free speech angle. What else?
There was also criticism, maybe more practical, that the court initially just left this really complex balancing exercise, privacy versus public interest, largely up to the search engine providers themselves, like Google.
Right, so Google suddenly had to become the judge in potentially thousands, maybe millions of cases. That sounds difficult.
It was a massive undertaking. And Google itself, well, they expressed disappointment with the ruling. By December 2014, just months later, they reported getting over 185,000 requests for link removals.
Wow, 185,000 requests. How many did they agree to?
They indicated back then they had refused about 60% of them.
So refusing more than they accepted. That highlights how tricky that balancing act is.
It really does. And it puts a lot of power in the hands of a private company to decide what information remains accessible.
It's worth remembering the Advocate General's warning here, isn't it? The one the court didn't follow.
Absolutely. The AG had strongly cautioned against this, warned that forcing search engines to do this would interfere with publishers' freedom of expression, that it could amount to, quote, censoring of published content by a private party, and ultimately sacrifice pivotal rights. The AG really believed the solution lay with the original publisher, not the search engine.
So why did the court diverge so sharply from that view? What was the core difference again?
It really came down to the court seeing search engine activities as distinct and additional to publishing,
Really?
because they saw search engines as having this separate, powerful role in disseminating information and creating profiles.
Right.
They felt justified in prioritizing the individual's data protection rights over Google's economic interests, and in many cases, even the general public interest when it came to name searches for non-public figures about old, irrelevant information.
Okay. So practically speaking, how did this start to work? If Google was refusing 60% of requests, people must have started complaining to the authorities, right?
Exactly. And the authorities needed a framework. The Article 29 Working Party, that's the group of all the EU national data protection authorities.
Okay.
They acted quickly. They published guidelines with 13 criteria to help them handle what they correctly anticipated would be a flood of complaints from people whose requests Google had denied.
So trying to bring some consistency to how these cases were judged across Europe.
Yes, setting out factors to consider, like the person's role in public life, the nature and sensitivity of the data, the age of the data, the public interest, and so on.
And looking ahead, did this ruling influence future laws like the GDPR?
Massively. The right to be forgotten, or more accurately, the right to erasure, was explicitly included as Article 17 of the GDPR, which is being finalized around that time and replaced the old 1995 directive.
So it solidified this right into the main EU data protection law.
Yes, and the GDPR version potentially went even further in some respects than the right derived from the old directive in the Google Spain case. It showed a clear, continued commitment in Europe to strengthening individual control over personal data.
Wow. Okay, so this deep dive into the Google Spain ruling, it really shows just how incredibly complex it is to balance individual rights with the free flow of information, especially now in the digital age.
It's truly fascinating, isn't it, how a decision based on a law from 1995 completely reshaped our understanding of privacy online. And it highlights that constant tension, the right to remember versus the right to, well, erase the past online.
So here's something to think about as we wrap up. Consider your own digital identity, how it evolves over time. In a world where information, once online, can potentially live forever, how much control should you actually have over your past self?
That's the million-dollar question, isn't it? And who ultimately gets to be the arbiter? Who decides what information stays accessible and what should be allowed to fade into the digital past?